Welcome to the Law Awareness Weeks at CDC 2023. Now, this webinar is part of Law Awareness Weeks at CDC 2023. It is a collaboration between Bono SG, the 5 Community Development Councils, National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. My name is Shu Ping, and I am your host for this webinar tonight. Today's webinar is on advanced legal planning on wills and end-of-life matters. First, to start off, some housekeeping matters. Today, we'll be using Pigeonhole Live for our Q&A sessions. You can submit your questions at any point during the webinar, and also upvote on any questions that interest you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is Law CDC 2314, as shown on the slide. Alternatively, you can click on the link shared in a chat function to launch Pigeonhole Live on your device. If you're viewing this webinar on your desktop or laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. Well, planning end-of-life matters is generally a daunting subject for most people, whether it's considered a taboo subject or because it's simply a complicated subject that people may misunderstand or prefer not to address. Our panelists are here to help us unpack these matters and gain some better insights. With that, I would like to introduce our panelists for today's seminar, Mr. Shen Kiat, Dr. Adeline Lam, and Ms. Julia Lee. Mr. Shen Kiat is the Managing Director of Kith Law Corporation. He has experience advising on the care of mentally incapacitated patients, how to deal with individuals' personal welfare and property and affairs through the LPA or lasting power of attorney, deputyship in the event an LPA was not created, and drafting of wills. He is a registered professional donee for LPAs, a registered professional deputy for deputyship, and a member of the Society of Trust and Estate Practitioner. Dr. Adeline Lam is a senior consultant in general medicine and clinical co-lead for advanced care planning in Tock Seng Hospital. She's also a member of the National Advanced Care Planning Steering Committee. Ms. Julia Lee is a senior director with Touch Community Services, having spent 31 years of service with Touch. She's a registered professional donee for LPAs, a registered professional deputy for deputyship, and won the Outstanding Social Worker Award in 2014. In her work, she's experienced in managing ACP, Advanced Care Planning, and end-of-life conversations, workshops, and talks with the community. Shen Kiat, Dr. Adeline, and Julia, thank you for joining us tonight.
Thank you.
Thank you for having us.
Okay, addressing end-of-life matters usually starts with considering a broad overview of an advanced care plan, or what we'll call an ACP for the rest of this webinar, which is to plan and document healthcare options ahead of time. So, Julia, in your years of experience in the social services sector, you have helped individuals create ACPs. Can you share with us why it's important for every person to create an ACP, and what are the instruments you would typically recommend individuals to consider?
Well, when it comes to end-of-life matters, it is often treated like a taboo subject in our society. So as a social worker working in the community, it is very common to see seniors avoiding the subject because nobody likes to talk about it or think about it, especially talking about death, right? So they will another group will always try to like procrastinate and put off having such conversation with their loved one. It does take a long time before some of the seniors will take action to actually work on those, start doing end-of-life planning. So when it comes to end-of-life matters, right, we all know that it is not an easy topic especially when it comes to making your own plans, deciding what we want, and talking to your family about it. So it can be really daunting and challenging for many individuals. So, but it's something that we all need to do or need to face, because death is actually inevitable and we all want to finish well. So you may ask, like, so what is end of life planning? Why is it so essential if you want to finish well? Well, the answer is very easy. It's very simple. The last thing you want is for your family to have to guess your wishes for medical treatments, or your family members to have conflict and disagreement when you are seriously ill, or when it comes to dividing your estate after you're gone. So to make end of life planning easier for you to understand, I actually want to split it into two categories. These are the documents that you may want to consider looking at before you die and after you die. So before you die, especially if you become seriously ill or have lack mental capacity, there are a few things that you may want to consider. Number one is making advanced care plan, or ACP. Advanced care plan is actually a document that you can lay out your wishes for medical treatment, ensuring that your healthcare team and your nominated healthcare spokesperson know exactly what you want when you become seriously ill. It is also a way of ensuring that your wishes are known and respected. So making an ACP is actually very crucial. Depending on your health, there are different types of ACP that you can make. If you are currently healthy, start with an ACP general form. And as you age and your health deteriorates, you can then have more detailed discussion with your healthcare team about disease-specific and preferred care option. The next document that you need to look at is another legal document called the Lasting Power of Attorney, or LPA. This is actually a very vital legal document that deserves serious consideration if you are thinking of doing end-of-life planning, because it allows you to appoint someone to make decision for you when you lack mental capacity. This trusted person or donors that's actually listed in your LPA is a person that you appoint to actually make decision on your behalf about your personal welfare and property and affairs. So the other document that you may want to consider is an advanced medical directive, which is actually quite optional, although it's a legal document that you can actually want to make. This document basically allows you to communicate in advance how you want to be treated when you're seriously ill. So to summarize, before you pass on, there are three important documents that you may want to consider making, which is advanced care plan, ACP, lasting power attorney, LPA, or AMD, advanced medical directive, while you're still alive. Now let's talk about planning. What happens after you die? This is where making a will will come in. After you die, making a will is actually quite crucial. This is another legal document where you give instruction and make your intention known, avoiding potential conflicts or uncertainties that may arise regarding how you want your estate to be settled after you die. It's a way of ensuring their assets are distributed to your beneficiaries according to your wishes. So I want to emphasize once again that if you haven't started doing your end-of-life planning, I strongly encourage you to actually plan early, because it makes things easier for your loved ones during a medical crisis and help reduce potential financial emotional stress for your loved ones. And also give you a peace of mind knowing that your wishes are known and respected. After today's webinar, please take the time to plan and have that conversation with your loved ones so that you'll be prepared for the future. And it's actually a very important step that can make a huge difference.
Thanks, Julia, for your insights. So I think you have touched on all the different documents. Thank you for giving us an overview. So let's start with breaking them down. And let's start with the ACP, which is the first one you mentioned. So one of the common considerations or occasions when ACP is likely to come up for consideration is when a person faces a medical situation. So Dr. Adeline, will you be able to share with us what an ACP discussion looks like from your perspective in the medical field, and why it's important to have one at this stage?
Thank you for that question, Shu Ping. So just carrying on from where Julia left off. So after you have advanced care planning, this discussion is actually uploaded onto the ACP IT system, and it's easily retrievable by the doctor through the National Electronic Health Records. And that's very important because when a patient comes in, they come through the emergency department in the hospital. So the doctors at the emergency department need to be able to retrieve this information if the patient is too unwell to participate in discussion with the doctor regarding the medical treatment. So what I mean is that if the patient is well and able to participate in a discussion with the doctor, we don't necessarily refer to the advanced care plan. The advanced care plan really kicks in when the patient has lost medical decision-making capacity, either because of serious illness or because of a chronic illness that has not been diagnosed. It becomes very useful when the patient is unable to participate in a discussion with the medical team. The important thing about doing your advanced care planning earlier, as Julia mentioned, is that you never know what to expect. You don't know what the future will bring. So if you share what your views are, what is important to you, what kind of interventions is acceptable for you, and which ones are not, and you share this with your family or your spokesperson, then when you're unable to speak up for yourself, this can then be shared with the medical team, and the treatment given to you will then be very much person-centered and what you would want if you were able to speak up for yourself. So maybe I can share an example of what can happen in the hospital. So, dialysis is a very difficult decision for elderly patients. If you're young and well, sometimes dialysis and renal transplant can be an easier discussion. But for an elderly person with multiple medical problems, dialysis becomes a very difficult decision to make. And you can imagine what the family will have to go through if the elderly person hasn't shared any views at all. So I had an elderly patient who was under my follow-up for many years. And as she grew older, her kidney started to fail. And we started discussing about how she felt about dialysis. And after much discussion and sharing with her what is dialysis, what it entails, she decided that it was just too burdensome for her. So when I did the advanced care planning with her and her family, she could share with us what her thoughts were, what her feelings were about this, why she felt it was too much of a burden for her. And that helped the family really, because they heard the words through her own mouth, through her words, and that made a real impact. And eventually, when she did finally succumb to the illness, became more symptomatic, the patient's family was not in crisis. They knew exactly what she wanted. So the plan that she wanted could be carried out quite smoothly. Family didn't have any decision crisis. They didn't have to argue or debate about what should be done for the patient. They remembered what mom wanted, and they could respect her wishes and really help her carry out her wishes. And she wanted to be at home. So we eventually arranged for a home hospice to support the family. And she went home and spent her last days at home with her children and the grandchildren, exactly how she wanted. And that's why I really support advanced care planning, because you could actually help to facilitate what the patients would want at the end of life, and also at the same time relieve the burden of guilt from the family. And in the end, it becomes it helps the family grow closer, because they all know what mom's goals were, and instead of having like a decisional conflict, they actually all band together and help mom reach that goal that she wanted. So that's why I think it's an important discussion to have. Hope that helps.
Thank you, Dr. Julia. So I think while we're on the topic where you talk about ACP being able to encapsulate the wishes of the person involved, right? So I think there are some of our listeners who want to know, can they also put in things like preferred funeral arrangements, including, religious preferences, etc. Will you be able to share that?
Okay, thanks for that question. Very interesting question, actually. So, the advanced care planning form, at the end of it, we have an actually empty section where you can fill in some of your wishes. And we do fill in some of these very special wishes. Not everybody has particular funeral arrangements that they want or particular wishes that they want. But if they do have it, we do have a section that we can actually fill that up. More importantly, two questions that we usually ask is the preferred place of treatment. So meaning that when you become very ill, where do you want to be treated? Do you want to be treated at home, in a hospital, in a hospice? That's quite important for a family to be aware of. And the other question is a preferred place of death. So some of our elderly really want to go home and spend their last days at home. And so it's good for them to have the opportunity to actually share with their family this wish of theirs. Because sometimes, it's really hard to bring this up in the middle of like a family dinner. It's just not appropriate. But if you actually have this opportunity of ACP facilitation, then the facilitator actually facilitates that conversation and allows it to actually come out quite smoothly and quite naturally, and it doesn't make the family feel awkward or uncomfortable. So we're just hoping that it's like a communication tool that allows a family to communicate about certain things that are a little bit taboo sometimes, but then with this kind of communication, you're able to share a lot of things.
Thank you, Dr. Julia. Sorry, Dr. Adeline. So, Dr. Adeline and Julia, I think we talked about ACP at some length, and we tend to think of the ACP as a document to, document wishes for some kind of perpetuity in case a person, is not able to make decisions anymore. So once this ACP is created, in your experience, can the individual change the ACP?
Yes, the individual can actually review and update their ACP as they age and as their health deteriorates. In fact, sometimes some of them actually consult the doctors so that they can actually choose their preferred choice of treatment.
Maybe I can add to that. So in the hospital, when the patients come in at each admission, we do ask them whether they've changed their minds, anything has changed about their advanced care plan. And if they have, then we will try and amend it for them online. That's quite easily done. Other things that would trigger a review of the advanced care plan would be any change in their medical circumstances. Say the diagnosis has changed, either the treatment has become effective, or there's a new addition to the family. Maybe there's a new grandchild and their wishes change. For example, I mean, we don't know what the future holds, but things change, and we accept that things change. So the advanced care plan is not set in stone. It can be changed when things around us changes, and we can always change our mind.
Thank you both for sharing this insight. So let's move on to the other documents that I think, Julia, you mentioned earlier on. So we touched on some of these documents, which are actually legal tools, like the lasting power of attorney, the LPA, and the will, of course, and then also a little bit on the advanced medical directive, or AMD. So Shen Kiat, at this point, will you be able to help our audience differentiate between LPA, a will, and maybe a bit of AMD?
Yeah, I'll try my best. So in a nutshell, as a lawyer who deals with estate planning, we call this suite of instruments that Shu Ping just mentioned as anticipatory decision-making instruments. In a nutshell, broadly speaking, we are looking at two situations which Julia has kindly alluded to earlier. The first situation is if you don't survive, right? If you don't survive, you're looking at instruments like wills, trusts, and also CPF nominations, insurance nominations, etc., right? And in the other situation in which you survive, but you're not well, right? And that's where instruments like LPA, possibly AMD, ACP, they come into relevance. As a starting instrument that I would really like to elaborate on, it's really will be a lasting power of attorney, because from my perspective, the single most most effective, easy to execute, and extremely important legal document for your caregivers, right? And essentially, it's a legal document that allows you to appoint proxy decision makers to manage your financial matters and also your personal welfare in the event where you are mentally incapacitated and are unable to do so. So LPA in a sense is important because it buys time for yourself to do other areas of your planning, right? So just in case if you lose capacity in the midst of estate planning, you have an unexecuted will, you have an unexecuted AMD, this can be resolved with a validly executed LPA. So a will is different from LPA, and oftentimes people confuse a will with an LPA, right? So a will essentially is a legal document that decides who inherits the estate and how to release the assets to the beneficiary. It's very straightforward in that sense, right? As a broad philosophy. A will takes effect when a person dies, right? So until the person passes away, your assets going to belong to you. It's not going to flow to anyone, right? And contrast that to a lasting power of attorney, it takes effect only when you are alive, but lack capacity. Once you passed on, the effectiveness of the LPA will be terminated. So that's a very important differentiator. And also, I see LPA as an instrument that improves your own quality of life, right? You make an LPA so that you empower your caregivers to maintain or even improve your quality of life. Your caregivers basically will be an extension of your personal autonomy in terms of how you want your money to be spent on yourself and also on some dependents, and also how you want certain personal welfare decisions to be made. Whereas for will, in Chinese, there's this saying, 前人种树，后人乘凉, right? You plant a tree, but other people enjoy the fruits of the tree, or they enjoy the shade of the tree. So essentially, it's to bless other people. So the concept in that sense is very different. Last but not least, there's the Advanced Medical Directive. I share similar views with Julia on the effectiveness of AMD, but essentially it's a legal document that cannot be executed by lawyers. Only doctors can sign. So doctors can play the role of a lawyer for AMDs. Essentially a legal document where you can make with a doctor and another witness that deals with a situation where if a person is terminally ill, facing imminent death, no hope of a temporary or permanent recovery, is in an unconscious state or unable to make a rational decision, right? So provided that all these factors that I mentioned are present and they have to be determined by 3 doctors, right? Of which, one must be the treating physician and then 2 other doctors. I'm not sure whether they have to be specialists, but finding a doctor is so hard, right? Much less finding 3 doctors to certify all these conditions. And after these conditions are certified, what happens next is that one of the doctor, right, or one of the healthcare professionals have to then call this registry, MOH, to inquire whether the patient has made an advanced medical directive. As you can probably guess, the process of finding out whether someone has made an AMD is actually quite cumbersome. And the purpose of AMD is really to make sure that someone dies naturally, right? But the effect of it is that people usually, from what I've heard from my clients, they tend to, their loved one tend to be intubated and all this stuff because it's just not possible to realize that they have made an AMD in time. Yeah, so that's essentially the differences between healthcare wills and AMD.
Thanks for sharing about the different documents, and AMD doesn't sound very popular, but let's just to wrap up AMD. Dr. Adeline, you care to give a view from the medical perspective of AMD?
Okay, I agree with Julia and Shen Kiat. Not a big supporter of AMD. I worked like 20 years in a public hospital. I've never activated a single AMD. There are multiple forms of appeal, I think. And we're not allowed to ask the patient if they have had an AMD done. So I would say it covers a very narrow spectrum in the patient's healthcare trajectory. So you can imagine as a doctor, this is really only applies for that 1% of time when the patient is, terminally ill, death is imminent, and then quickly get 3 doctors to come and certify this is so, and then activate the AMD. Whereas I would actually be supporting advanced care planning, which can be activated when you have lost mental capacity, and it can cover so many areas of your healthcare. It can involve operations, it can involve whether you want blood transfusion, whether you want recurrent admissions to hospital, or you prefer to be treated in a nursing home or at home by the home care team. It can also include the artificial feeding, which is a very topical subject actually, and good to discuss early before you lose your mental capacity. So it can cover a lot of things that will become important as you get older and there are more medical issues. And this is just not covered by the AMD, and that's why I think it's not wrong to do an AMD because it is a legal document, but it just doesn't cover very much. So if you're going to do an AMD, remember to also do your advanced care planning.
Yeah, total defense.
Okay, thanks. I think we will wrap up our discussion on AMD here and focus on, I think, the two other documents also. I think, Shen Kiat, you mentioned LPA, so did Julia. So Julia, I wanted to understand, from your perspective, can you share an example how an LPA has really benefited an individual or not benefited, and in what ways your team has assisted an individual to either apply for or handle the LPA?
Okay, maybe I can share a case. We had a client who lives alone, and he recently attended one of our talk at our Touch Active Aging Center. And after the talk, he actually made LPA. This particular senior is actually 70 years old, and he's a widower, lives alone, and has a host of health problem. And after he made the LPA, 3 months later, he actually had a stroke. And it's really fortunate that he actually done an LPA, because he's actually a lifesaver for him. So with the LPA made, the son can now step out as a donee and immediately take charge and handle his finances as well as his care arrangement. So you can see the benefits of actually having an LPA done very early. Because the LPA provides a legal framework that ensures that the appointed donee is able to act in the best interest of this person, and also at the same time ensure that it will safeguard also and protect any potential financial abuse or mismanagement, because all this is actually covered under the Mental Capacity Act and gives a lot of protection for the individual. So it's a good news, right? That you actually that we have this instrument that we can use, which is an LPA. For those people, individuals who don't have a loved one who can step forward to make an LPA, you may want to consider getting a professional deputies and donees to come in to actually act for you. The Office of the Public Guardian actually have a list of registered professional deputies and donees on the website, okay? So if you are looking for donees, you can actually appoint a professional donees. So the names and the contact numbers are actually, if you go to the website, there's actually lawyers, accountants, and even social workers that you can appoint for a fee, all right? The charges is between $300, $200 to $600 per hour when it's activated, when your LPA is activated. Yeah.
Julia, your charges $200 per hour.
It all depends. Yeah.
Thank you for sharing that. Okay, so I think now we've talked about all these documents and we said, these are legal instruments. I think our audience is actually curious, how many of these do I actually need to go to a lawyer? So, Shen Kiat, from your experience, don't know whether a conflict of interest or not, but from your experience, how would the individual benefit, from legal advice or consultation?
Yeah, it's a very good question, Shu Ping, that we get all the time, right? Why do we need a lawyer to execute any of these documents when sometimes, and I can see why people think it's that way, it's just a matter of form filling, going through some processes, and ta-da, they get the instrument executed. I think the benefit of lawyers really is firstly, they let you know what you don't know, right? So forms are, in a sense, well, I guess forms or what we call formalities, right, of execution basically deals with how can we ensure that a document is executed properly, right? So to make sure that it has legal effect when it needs to be applied. So that's one part of it. The other part is the substantive law part, which is the contents inside the document, right? Whether it's the LP or the will, does it serve the purpose that you are, concerned about? What is the strategy behind the way the contents of both the LP and the will are drafted, such that it fits your caregiving strategy for yourself and also for your loved ones? So in that sense, the lawyer will be very, very useful. I give you an example. I have a client who came to me wanting to make a will and an LPA and basically execute a estate plan. And she told me that, actually, Shen Kiat, I have 3 children. I have a joint account with all 3 children. They are able to use my money to take care of me in the event I lack capacity, right? Because it's a joint bank account with joint alternate permissions. And he said, do I really need an LPA? And then I asked this client, which child is the most filial to you? Which child do you think will use the money as a joint bank account first, right? I guess that's one. The second would be, who's the actual owner of the money as a joint bank account, right? And I guess most of you, most people have this understanding that for joint accounts, usually when a joint account owner passes on, the surviving joint account owner will benefit from the monies in the bank account. That's the usual narrative, right? But I can tell you that's not always true. And increasingly, we've seen cases where the ownership of joint account monies have been contested, right? So it could be contested based on who contributes the most money to the bank account. What was the intent behind setting up this bank account in the first place? And there could be different stories behind that. So my point is also that coming to a lawyer highlights certain pitfalls of your strategy, if there's one in the first place, and we make sure that what you have actually allows for frictionless caregiving experience for your caregivers.
Thank you, Shen Kiat. And I think our audience also may be curious, I think besides the advice, and on the substantive law aspects as well as the drafting, I think a lot of them are actually asking, what they have seen websites providing certain will generating services, like My Legacy at Life SG or Will Generator by OCBC Bank. So are these actually valid and legally acceptable? Do they have to come to a lawyer?
Yeah, so these will generators, the form itself, right? If you fill out, it's a questionnaire, you fill out the blanks, they generate something, and then you have to execute yourself. And then they have a FAQ that tells you how it should be executed. And then they have 101 fine print to tell you that you're not responsible if something goes wrong. And I can tell you, I have there will be situation where clients who use these will generators, they had something gone wrong. And so one of this case happened relatively recently, actually. So this guy, he used the will generator. He thought he has a very simple situation, which is he only had 2 kids, 2 sons, and he just wanted to pass everything to the son. And so I think at the advice of his financial planner, who is, I guess, affiliated to OCBC because they use the OCBC will generator. They generate a document, and then the will was witnessed by the spouses of his 2 children. Some of you might not be aware, you know that, to be the witnesses to a will, you need 2 independent witnesses, and the witnesses cannot be beneficiaries of the will. But it's also not very well known that witnesses cannot be spouses of the beneficiaries as well. And in this particular case, when we had to admit the will for probate, we realized that the spouses were the witnesses. And this actually had the effect of negating the inheritance meant for the children inside the will.
Oh.
And nowadays, because I sit on this probate practice committee on the Law Society, and we have regular dialogues with the family court judges that deals with probate matters, and they've been telling us that if they see a will that is not witnessed by a solicitor, they'll usually ask for what is known as an affidavit of due execution. An affidavit of due execution essentially requires the witnesses to the will to explain the circumstances in which the will was executed, because the court doesn't have the confidence that the witnesses are familiar with the laws of execution, and they are sticker to make sure the formalities are followed. Yeah.
Okay, thanks. I think this solves quite a burning questions for a lot of our audience. So I think there are some more questions in relation to some of the formalities, etc. I will leave it to the Q&A so that our audience can consolidate all their questions in the meantime. So I think we have heard from on all these different documents, maybe from and different types of end-of-life planning. So planning aside, are there any other practical aspects you would like to highlight to our audience about end-of-life planning? Anyone want to go first? Maybe Julia?
I think in end-of-life planning is not a one-off exercise. Even though you put all the ticks and the boxes, you may need to come back to it, because your life circumstances may change over time due to your health condition. Even your marital status may change. Your finances may change. So it's always good to revisit, to review, and also to update your LPA, your ACP, and also your will. For myself, I actually revised it 2-3 times already. Yeah, so it's not a one-off exercise.
I can add to that. I think end of life discussions are difficult. We have to face it. It's not an easy discussion. And so I feel that communication tools such as the advanced care planning discussion is a way to discuss difficult topics in an open manner and allow the different parties to share their thoughts and views and kind of have that discussion, difficult discussion much earlier rather than wait till crisis time and then have that discussion. And once everybody has has shared their views, then when it comes to decision time, crisis time, there's not that decisional conflict that you'll get when no one has thought about it, So I think it's good to have early discussion, use this kind of tools to do the discussion, and be open to it, I suppose. Yeah.
Yeah, I would say don't be overwhelmed. Start with something. And in my case, what I started in my family was the LPA. So I told my dad that, hey, Dad, you got money, right? Me and my sister, we love you very much. But if you rely on us, at best, we might be able to pay for maybe up to an A-class ward at the government hospital for you. But you have insurance monies, right? You have your lifelong savings. This is meant for your quality of life. So if you appoint us as your donees, we can apply this money towards your welfare, right? So it's a bit of a fear-mongering, I guess. but that really got him thinking, and yeah, okay, and that makes sense. And that's how my family started on their ACP journey.
Thank you
for sharing, because I tried to do it on my family, but it didn't work. So I'll have to keep trying. Every time I try to bring it up, they'll be like, you're a doctor, you make all the decisions for us. But I've got like another brother and sister. They might have different opinions, and they are in different countries. So nowadays families can be in different countries. So my sister is in Australia, my brother is in another part of Australia. So we don't really meet each other all that often. So it can be difficult. So although I say, try and do the discussion, I've tried myself, I failed myself. But don't give up.
Yeah, I saw the difficult conversations, right? Because I used to be disputes lawyer, and then my parents would say nothing will happen. You and your sister will work it out eventually. The assets, everything, or your sister's not really one. I said that's not the point. It's just sometimes things change. We don't know how circumstances change. It's just better to have some kind of to have it all documented and known rather than have to think about it. Yeah,
I agree.
Thanks for sharing. Now, I think so far we have talked about, we have actually mentioned a few times about loved ones not having to, have a conflict or make decisions on behalf of the individual, right? So what about if, I think this is an interesting question from our audience. What about in a case where there's a single individual, no close relatives or friends, don't really want to rely on extended family. So what options are available to them? Who should they approach amongst the three of you for which documents?
They can do all three documents actually, as long as they have their mental capacity, they can still make decisions.
I personally would suggest that they will start with ACP simply because even if they have a professional to act for them, the professional may not have any next of kin to get in touch with, to understand the wishes, right? The care preferences, the financial map / status of the client. So usually I would suggest for someone in that single, maybe elderly, no next of kin, no friends to appoint, start with ACP first. So once you know what your own quality of life regards to end of life planning looks like, then you can have a more fruitful discussion with the professionals, whether they are social workers, accountants, lawyers, doctors.
What about like the professional deputy that Julia mentioned? Would it be useful in this kind of situation?
For professional donees, when they will come in, usually to encourage to also get your ACP done, because healthcare got to do with money. All right. and you need money to take care of you when you are mentally incapacitated. So actually it's all interrelated. You can always start with ACP and then do your LPA, or you start with LPA and then work on your ACP. Either way is fine. But get going. Work on one first. All right. So for people who actually don't have a loved one that they can depend on to act for you as a donee, in cases like, people who come to us are usually, sometimes they are singles who don't have family members, or the family members are too old to act for them, or may have some health challenges. We also have family members who are living overseas. So these are cases in actually they will approach a professional donee to come and act on behalf of them. So to get a professional donee, you just need to go to the OPG website, and actually there's a listing of professional donees that you can talk to and consult with.
Okay, thanks. I think we sort of concluded our experience in terms of all the 4 different documents. And I think what we want to do next is a kind of case study to just showcase how these different documents can work in certain situations that occur in day-to-day life for various individuals. So let's move on to a case study, and maybe our panelists can help us to explain, what happens then and what to do then, or why something didn't work or did work. Okay, so let's go to our case study for the first part. Now we have an individual just like you and me. So Mr. Gopal is turning 60 in 2 months' time and looking forward to a well-deserved retirement. And his children are in their tertiary education. And they have been starting to ask him to consider his end-of-life plans. But Mr. Gopal feels he's in a pink of health and thinks it's too early to start talking about this topic. So something like what Dr. Adeline described earlier. So in this case, Julia, what would you advise Mr. Gopal and his family to do? And how would you, how would you approach an individual like Mr. Gopal to convince them? Yeah.
So starting a conversation about end of life is very difficult, especially for family members. So here are some conversational guidelines actually for the children who are thinking of starting a conversation with their elderly parents. So the first thing to do is actually to choose the right time and place to do it. Find a quiet place, quiet, comfortable place, and make sure there's no distraction so that you can have an uninterrupted conversation with your loved ones. Then you can facilitate the conversation by getting them to express their concern and let your family know that let them know that you want to ensure their wishes and desires are respected when it comes to end-of-life planning. All right. The other thing that you can actually encourage the conversation, get the conversation going, is to ask a lot of open-ended questions. Okay, so some questions that you can actually ask is actually like, what are the thoughts on end-of-life care? Have you considered any preferences regarding medical treatment and so on? So as they are expressing their thoughts and their emotions, listen attentively and try to be as supportive as possible so that they feel comfortable in expressing themselves. And lastly, if you really cannot hold that conversation, then get a third party to come in, all right, to help facilitate that conversation. So for ACP, you have ACP facilitators. For LPA, you can always get a lawyer or somebody else, a social worker, to come in and get the conversation going. Yeah, those are my thoughts.
Okay, thank you very much for sharing that. So I think, assuming we've been very successful in convincing Mr. Gopal, so his children have encouraged him, then he decided, okay, maybe I'm 60 years old, I should go for full body health screening. So he thinks, never mind, I just want to put their minds at ease. So he still believes he's too young to encounter any major health issues. And he has faith in, Singapore's healthcare system, like Dr. Adeline's team, to take care of any symptoms he might face. However, in the review of his health screening results, the general practitioner told him, your cancer markers are slightly elevated. So he advised Mr. Gopal to make an appointment with an oncologist just in case. Now, Dr. Adeline, in this case, I think you might have seen such patients coming in, a bit suddenly spooked by all these kind of health screening results. How will your hospital's personnel then be able to assist Mr. Gopal to do like an ACP or any other documents apart from the medical examination?
Okay, thank you for that question. Okay, I'll try to answer this question. I think first and foremost, if I do get a patient who's just been given some negative results, it is really not a good time to do your advanced care planning, because a lot of things will be going on in your head. What does this tumor marker mean? What do I have? Am I going to die? Am I not going to die? Do I need to go through chemotherapy, surgery? So many questions. So when you're in that kind of state, that is called crisis mode. And crisis mode is not when you want to do an advanced care planning. So what I would advise Mr. Gopal would be to ask him whether he's keen to go on to do some investigations to see how he is, whether there is truly an abnormality that he needs to pursue. Now, if Mr. Gopal feels that due to his own healthcare values, he doesn't want any further investigation because he doesn't want any treatment anyway, and this is something that he feels very strongly about, then maybe the advanced care planning can proceed from there. But if, let's say, Mr. Gopal is still keen to do, CT scans and maybe a gastroscope and things like that, then I'll probably encourage him to finish off the investigation. Let's get a diagnosis, get a management plan, and then we sit down and discuss what's coming up ahead, what are his thoughts, what are his values and his goals, and then from there, we can go on to an advanced care plan. So that would be what I would advise Mr. Gopal and his family. We can definitely do advanced care planning in the hospital. We've got facilitators in our medical team, the doctors, the nurses, our social workers. We've got an ACP team as well, who are coordinators who can also come in and help facilitate a lot of this advanced care planning discussion. But a lot of times we want to get to that discussion only when the time is right. Because if you start the discussion too prematurely, it will not result in a good outcome, or it may not result in a good decision, shall we say, because you're in a panic mode. It's very hard to make any decision. So yeah, I would say talk to Mr. Gopal, see how he feels before we proceed on to advanced care plan.
Actually, just curious, usually in this kind of situations, after they've done all the medical examination and tests, etc., how often do they then come back to get the ACP done?
Okay, so if let's say this is in the inpatient setting and we've sorted out a lot of things, we try to do the advanced care plan before they leave the hospital, because the opportunistic situation of being in the hospital makes it easier for the ACP to be facilitated. But again, if there are a lot of tests that are still pending, I wouldn't do the advanced care plan. I would probably see him back in my clinic, see how he's going, get to know him, get to know his family, and then do the advanced care plan a bit further down in a few months when things are a bit more settled. I know it's like, we should do it as soon as possible, but I think we should do it when the time is right. And if there are things going on, then we get the things done before we go on to the discussion. And I think then it will be a very fruitful discussion.
Okay. That sounds interesting. Yeah, and good to know that there are always avenues, and I think the medical personnel would actually advise or remind, family members or even the individual himself or herself to come back to make an ACP. Yeah. Okay. Now in this case, we all assume Mr. Gopal is well and mentally able, despite having cancer markers. But sometime later, after Mr. Gopal's 65th birthday, when his children start to notice Mr. Gopal seems to exhibit certain signs of forgetfulness, and then it becomes more and more frequent that it starts to worry them. And his children also started to notice that, he used to be pretty easygoing, but then he started becoming increasingly irritable or snappy. So change in a disposition. So his family is worried about how to continue caring for him, as well as how to handle Mr. Gopal's assets in future. So Shen Kiat, let's say at this stage, Mr. Gopal's children decides, okay, we are past the social services or medical personnel assistance. They come to you. So what considerations or advice will you share with them, and what can they do at this stage?
Well, I guess first I will commend Mr. Gopal's children for taking all this effort to make sure that they are Mr. Gopal, right? And hopefully the mother as well is well taken care of in the event they are unable to do so. Usually in such a situation, we are mindful of the cognitive load that might be imposed on Mr. Gopal if we try to get him to think about the whole suite of estate planning instruments that ideally should be put in place in advance before anything happens. So in such a situation, as I alluded to earlier, I will usually encourage the family to focus on, at the minimum, put a lasting power of attorney in place, right? So in that sense, trying to figure out who should be your proxy decision maker, who should be your caregivers, right? That shouldn't take out too much of a cognitive load. And I think this is a decision that Mr. Gopal, despite his presenting conditions, should be one that she should be able to make. If obviously he's unable to do so because his condition is actually more severe than expected and he's deemed to not have capacity, then there are also other pathways to ensure that his caregiving needs are taken care of. But these pathways are more onerous in nature. It involves making an application to the court to get one of the family members or all of them to be appointed as deputies. So these deputies, laymen, proxy decision makers, to also make the same kind of decisions that they will be able to if an LPA is put in place. But the main difference will be that a court order is more restrictive in nature. The court is very mindful of who they appoint to take care of someone like Mr. Gopal, simply because this appointment is not exercised by the individual that is being cared for. It's not exercised by the care recipient. It's exercised by a third party called the judges. And because of that, they don't know family dynamics. They will want to be very intrusive on the personal financial circumstances and family history of the whole family before they consider what powers to grant and also who these powers should be granted to. So my point is there are different pathways. We take it one step at a time. But the main instruments that we should focus on will be the lasting power of attorney. obviously there might be also some concerns as to like how Mr. Gopal's estate might be dealt with, but I think usually that would take a path of its own, and we can deal with it later.
Okay, thanks. So I think this kind of also gels with one of the questions that we was asked. So I mean, you suggested to focus on LPA, right? So, but what if he doesn't want to do it, or I mean he can't, or he doesn't want to do it? So no LPA, then maybe no ACP. So I think our audience is concerned, will the care arrangements, etc., be contested? Can they be contested by their family members or siblings? And what legal recourse can Mr. Gopal have?
Mr. Gopal's children.
Yeah, I guess.
Well, so this would move the scenario a little bit different, right? Because then it seems like Mr. Gopal's children may not be in harmony, right? Total harmony with each other, right? And I think maybe that might be a reason why Mr. Gopal might feel a bit hard-pressed to pick someone, because he loves everyone, even though they don't love each other. So in such a situation, I think a court-appointed deputy will be the way to go, because that would basically leave the appointment of this caregiver to the court to decide, right? All parties can put in their case to advocate for why they are the best caregiver, right? And then, just live with the court decision in that sense. It's imperfect, but at least once the appointment is made, you know that it's done in the best interest of Mr. Gopal in that sense.
Okay, thanks for sharing that. I think we have exhausted a few circumstances, and I think changes in circumstances in Mr. Gopal's life. So I hope that he has been a little bit illuminating for our audience to go through to live his life with him as well. Yeah. So thanks for engaging session on end of life planning and all these various considerations. So I think it was very helpful to hear from all the differing perspectives, like from the social services sector and medical and legal fields. And to me, the most interesting was that everyone agreed the AMD was not helpful. Okay, so I think we also at this point want to open up the session to some of the questions submitted by the audience. I think we already covered some of them during the course of our panelists discussing these topics as well. So let me try to get through them. Please remember, you can still submit your questions through Pigeonhole. You can still upvote them as well. Yeah. So I think I'm just trying to categorize our questions a little bit. I think let's do the LPA first. I think a lot of our audience is very interested in finding out what are the steps to register for LPA. Because here we are hearing from, Julia, from Shen Kiat, where they have assistance on that. So they want to find out actually, can they do it themselves?
The short answer would be that you can do some of the form filling yourself, but eventually you will need a certificate issuer to sign off on your LPA to make sure that you are doing your LPA of your own free will, not under any undue influence or under any misguided representation of what the document actually means. But doing it yourself, as all of us had mentioned earlier, also means that you don't know what you don't know, right? And some of the now that the LPA has a longer history, about 12 years already, we are beginning to see some issues with how the LPAs are being used on the ground, right? So we have clients who actually run small businesses. They could be hawkers, they could be run a tuition center, right? And suddenly realize that, hey, the LPA does not allow my partner or someone else to actually run my business, at least the basic LPA form 1, right? And then that's where they realize, oh, this document is not what I thought, or at least the one that they signed is not what they thought they had actually signed. And also there are situations where, so in Form 1, you can appoint up to 2 donees and 1 replacement. I think I have also some clients who appointed the donees to act jointly only, and then they have 1 replacement. but they thought that the replacement will step in to only replace either of the original donors who are unable to act. But the law actually works in such a way where the replacement will step in to replace both donee A and B, both original donors, if either one of the original donors is unable to act. So these are very important, non-exhaustive, but very important issues that were not flagged up when the clients made their own LPA with don't know who.
Actually, I just wanted to share that recently I tried to fill in my own LPA. So I went to the OpGo website, and actually it's quite easy to get onto the website and fill up the form. The only part that you need to find someone else is to get it signed. Because it's just me and my husband. So I nominate him and he nominate me. So I didn't realize there were so many other little points that I need to be aware of. So, but I think if it's a simple structure, maybe we can use OpGo and then go look for a lawyer or a doctor to sign.
Like Form 1, right?
The Form 1, yeah.
Form 1. I think Form 1 does suit most situations. But the thing is, something can be simple, but with a million details contained inside, And I give you an example of one of these million details, right, that actually impacts all of us, but we are unaware of. So there's actually, just now I mentioned that we and LPA, they are considered separate instruments, but they do overlap in certain instances. So for example, LPA allows the donee to make use of the donor's financial resources, right, to take care of the donor. And then the will deals with distribution of an asset, right? But the law, a not very well-known part of the legislation, actually states that if an asset is converted during the activation of an LPA. So for example, in the will of the donor, the will says, I give property A to B. I give all my financial assets, that means the movable assets like bank accounts, stocks, etc., to person B, right? But when the LPA of this donor was activated and then the house was sold to fund his care, right? And now the house is no more. The house is basically just a collection of liquid assets, right? Money, right? Does it mean that B will get everything in the person's estate? But the law actually says that the donee needs to account for the conversion, right? And that whatever remains of the conversion will still belong to A, even though in the will, A is only entitled to immovable property and not bank account monies. So there's actually a lot of responsibilities. There's a lot of responsibilities on the part of the donees. So the donor can happily, get the donee go and use SingPass and sign and what's not. But do they know the full extent of their legal responsibilities? Do they know the scope of their duties? Do they know how to use your LPA in a way that is compatible and complements the rest, your will and the rest of your estate plan strategy? I think that's where the value of, having a conversation how these instruments actually work and not just collecting instruments per se, it's so important.
Interesting.
Yeah, this kind of links to one of our questions where I think our audience asks, does a validly executed LPA, can it resolve an unresolved will or ACP? So I think this is what you're alluding to, right? The complications or needing to kind of tie the drafting in the different documents together.
Yeah, so one component of LPA deals with able to make personal welfare decisions, right, which also includes medical decisions as well. So I would expect that any medical professional, even in the absence of an AMD or ACP, if there is a donee in place, as long as the donee is perceived to be acting in the best interest of the donor, the medical professional will continue to take advice from the donee, right? So there might be an unexecuted AMD or an unexecuted ACP, but this can still serve as guidance, right, for the donee making personal welfare decisions for the donor. In regards to an uncompleted will, so this is a little bit more complex. It deserves a webinar by itself, but I shall not go into that. But recently we had a situation where we had a caregiver where there was a will that was unintentionally revoked by marriage. So basically the caregiver has, parents, they make a will many years ago. And And the caregiver who is actually a stepson of one of them didn't know that the parents were not married. So they only married very late, like maybe in their 70s, just so that they could right size from a private property to a HDB flat. But when they got married just to, get be able to buy a HDB flat, right? They didn't know and they didn't take legal advice. I guess you don't know what you don't know, right? That the act of marriage actually revokes a will made before that. So basically, everything actually, so actually both parents make wills where they give everything to the stepson. Because the stepson is not drama. The stepson is a very 孝顺, a very filial stepson. But because of that, it's going to fall under intestacy rules, and the beneficiary is going to be unrelated people all over the world. So what we did was we actually got the caregiver to apply to the court to ask the court to make a will on behalf of the surviving parent who has already lost capacity. Yeah, so this is known as a statutory will, and the court, based on the evidence that we have offered that our client is really a caregiver, he's really filial, this will be what the parent will have done. The parent still has capacity. So there's actually pathways to make sure that the care recipient, right, who have really lost capacity, wishes can still be fulfilled, even though they are technically unable to sign off on these documents.
What if you have no will? What happens to your money?
If a person has no will, we have laws that prescribe who should benefit and to what extent they should benefit. That is the easy part. The hard part will be the facts. And I say the hard part will be the facts because nowadays we have blended families, right? Or we have people who with a child in the first marriage, divorce, marry again, then the two families not in contact, suddenly die. And how are we going to collect the information? How are we going to build a family tree? So the rules of distribution are quite straightforward, but the facts actually makes implementing the rules very difficult. Yeah. I'm not even going to touch about like asset tracing.
Yes.
that is crazy.
Digital world.
Yeah. So recently so there's this, I shall not name the company, there's this like insurance company that we wrote to, trying to figure out whether the deceased holds any assets, and the company told us no assets, but subsequently we managed to obtain the last like 24 months bank statements of the deceased, for, the main bank account, and then we realized that there's actually a payment made to this insurance company. And then we wrote in again and say, hey, there's a payment made, can you double check again? It turned out that there's actually $500,000 of insurance money that they totally left out. So there's a lot of detective work, and you cannot just take it for granted that when you engage an institution, they will come back with the correct information. But all this can be resolved if you, as the caregiver or prospective care recipient, just set up all your documents and information properly.
I just want to add one small point. When I was in practice, I had to help people administer the will, and you assume all the assets are in Singapore. Oh my God, I got this. I remember that my father told me 10 years ago he had a pushcart space in China. I'm like, oh my goodness. I thought it in India, and suddenly you're like, but I don't know the law in India, how to recognize the land. So yeah, better to have documents.
Challenging.
Cross-border estates is another thing.
Yeah. Okay, interesting. So, okay, back to LPA, right? I think a lot of people also ask, I think you touched on choosing donors and stuff like that. They want to know, who can they choose as a donee in LPA? Is there any criteria? Yeah. And when, okay, then maybe to add on also, when to select deputyship?
Someone who is trustworthy, someone who you ask them to lend you money and they will unhesitantly lend you money, because then they probably won't conduct financial abuse on you. I mean, no hard and fast rule, right? Someone who is trustworthy is definitely a criteria. And someone who, at least talking about donees, someone who is able to, younger will be one, but someone who is able to who you know have the courage to implement your care plan, especially when the care plan asks for no extraordinary life-sustaining treatment. It's actually not easy to watch a loved one waste away and not intervene. So I think trustworthiness and courage will be prerequisites.
Yeah, someone who doesn't freak out when there's crisis, right? Yeah, who's calm.
Who's calm. And obviously being able to, some sort of financial literacy will be helpful as well. Yeah, so I actually have a client who wants everything to go to her daughter, but knew that the daughter is not capable of taking care of her. So she appointed a professional donee, but make a will to give everything to the daughter. So she will let the professional donee use her own resources to take care of her, which is good because that minimizes the issue of possible financial abuse or what we call inheritance impatience. But at the same time, make sure that whatever's left over will go to the daughter as intended.
Julia, you have...
I think for myself, I will look for someone who is maybe somebody who is trustworthy will be a good decision maker, know how to weigh the interests of what is best for donor, and at the same time, able to keep proper records. I think it is important for you to document all your decisions and how you spend the money, so that if anybody were to challenge you, you are able to actually account for the use of the money.
Okay, so just to clarify, someone asked if the donee has to be a healthcare spokesperson. No, right?
That's a very good question. Very good question. The healthcare spokesperson is the person that you nominate for an advanced care plan, and the donee is the person that you nominate for a lasting power of attorney. And it can be the same person, or it can be two different people. I would say that the characteristics of both would be very similar. But I think it would be good to actually be the same person, and this person should actually be in the advanced care planning facilitation, so that you can actually hear what the patient really wants, what their values are, what their goals are. Because as a donee, right, you're given all this raw power, but do you really know what your parent really want if you never ask or you never heard what they never shared with you? Just give you the power to execute their money and say, oh, you know what to do. You're my son, But sometimes you don't know, Yeah, I don't know whether your dad likes a kopi o or iced coffee or iced tea, So sometimes little details. We just expect our kids to know, but they may not know, and so I feel that the ACP and LPA are very much intertwined. And if you're doing an ACP facilitation and you have a healthcare spokesperson, if this person is able to be your donee, then fantastic. And if they it's the same person and they set into the ACP facilitation, then they will know the patient well. They will know what their values are. The decisions will be very much in line with what the patient wants. It will be very much person-centered, and that's exactly what we want for our patients.
Thank you.
I have a slightly different view from Adeline. As in, I agree with her totally, but I also recognize that someone who controls the finances also have levers on personal welfare, even though they may not be directly appointed, right? Because they can decide whether they want to pay for treatments or not. So I think in that sense, insofar as practically possible, if it's the same person, that might be better.
Okay, and one question which also crops up is appointing donees or deputies. Do you need to pay a fee? Can they pay a fee if they want? And do they, write this inside the LPA form?
Okay, I think first and foremost, lay donees under the law, they are not allowed to be remunerated. Okay, so that is very clear. Like if you appoint your friend, you cannot say that I want to pay your friend a salary, okay? Because even if they take the salary, it will be against the law. The mental capacity and other related legislation does not provide for that, right? Only professional deputies and donees like Julia can accept payment for such services. What's the second part of the question?
I think linked So deputyship. So a lot of questions relating to donee, deputyship, when I can appoint, do I need to pay?
So when you appoint a professional donee is when you still have mental capacity. So usually the professional donee will ask you to sign a letter of engagement and the rates will be stated in the letter of engagement.
200 to 600, right? That's the one we mentioned.
Juliet might be a bit higher because she's very good.
Depending on which professional that you are engaging. Lawyers will be a bit more pricey.
Higher. I'm quite pricey.
Okay. Okay, so these are most of the questions on LP. Anything you want to add?
Yeah, just one thing. For court-appointed deputies, even though they go by an per hour rate, the main difference between that and a court-appointed, sorry, not court-appointed, a professional donee is that the court-appointed deputies still need to justify their fees to the Office of Public Guardian and to the court. So in other words, it's not a mere rubber stamp. The fees needs to be reasonably incurred. So in that sense, that is a safeguard. It's actually very legit, all the annual reporting stuff like that. So
and we need to put out a P-focus plan.
Yeah, P-focus. It's actually very painful. But I think a lot of people, I personally can attest that a lot of people who do this professional deputy and donation work they are really, really good people. Yeah, who happen to be professionals at the same time. So yeah, take your time to call the people on the list and find out more about them.
Please consider Julia and Shen Kiat as well.
So you mean on your LPA, if you say nominate Julia, then you put your name on the LPA form as a donee, is it?
They can always put down the donees that's listed in their LPA.
Okay.
Okay, so I think these are most of the questions on LPA. I wanted to leave some time on wills because also another big topic. So I think one question which comes up is nomination. So sometimes you can, I think you earlier touched on it a little bit, like you can nominate under CPF, insurance, so or also, joint accounts, maybe people can take it out. I think people want to understand what is if there's a conflict, what happens? What will take precedence?
What's the conflict? As in,
let's say you nominate someone and your insurance or the joint account holder took out the money, but actually inside the will is something else.
Yeah. So, okay. So at the most basic, you can only give away what is under your own name, and when I say under your own name, it also means what you are beneficially entitled to, like you're the ultimate owner, right? Or in legal parlance, we call it UBO, ultimate beneficial ownership. So I think if you're asking this question, means hopefully you're still alive and well. So it's very important to keep a good inventory of your schedule of assets, what you have, what's under your own name but actually belongs to someone else, what's in joint names and you actually want another person, the surviving joint owner to benefit. So as a pro tip, right, let's take the most common scenario for husband and wife. Usually when we do wills for husband and wife, we actually include a declaration inside the will to say that the spouses will want for all joint assets, whether is it property or whether is it bank accounts, they are in joint names between husband and wife, they will want the surviving co-owner to benefit. In other words, they want the law of the survivorship to apply. So that leaves no doubt as to the ownership of such joint accounts. So that removes one degree of uncertainty, especially when there's unequal contributions to an asset between husband and wife, right? Because the wife could be a homemaker, right? With regards to nominations, if you have made insurance nomination, it's very difficult to use a will to revoke that nomination, simply because revoking an nomination via will requires a strict adherence to prescribed MAS rules. Right, so MAS rules basically state that you need to state the insurance policy name, the account number. You need to state which insurance company, what's the surrender value. So basically, you cannot revoke it by mistake. That's what I'm trying to say, right? So usually revocation will have to be done directly. We'll suggest do it directly with the insurance company. So in this scenario where we make an insurance nomination last week, and then you make a will today that says that I give all my assets to, person B, it will not affect your insurance nomination. It will still proceed as a normal. As for CPF, it works a little bit like a trust. The money belongs to you, but you don't have direct control over it. So because it's protected by legislation, it is not yours to give away under your will. In other words, you need to make a nomination. And actually, this is also pro tip. There are actually two types of nominations that will be relevant to most your average typical Singaporean. The first will be the one that you can make online, where your nominees will receive the payouts from your CPF, as a direct payout to the nominee's bank account. The second will be what's known as an enhanced nomination, where your CPF monies will go into your nominee's CPF account. So you think that your nominee might not be financially literate, or you want to have a one-off injection of funds into CPF, because CPF, they hold money on trust, right? They also pay, relatively high interest, right? So actually it's a good strategy to use, actually. And also because CPF nominations, you can't prescribe replacement beneficiary. So what usually I ask clients to do is, so for example, I have a kid, right? I only have one child, 3-year-old. So I actually made my wife, maybe my wife might be watching this. I made my wife like the nominee. So she's 99% of my CPF monies, and my child is 1%. So that in the event where something happens to my wife, the deceased nominees share will revert to, and so will be shared with all the surviving nominees. So you don't have to make a nomination again. Yeah.
Okay. And then another common question is this, if I made a will or maybe LPA, how do my next of kin or whoever needs to know whether I've made one and where to find?
I think you should tell them. Communication is the key.
Yeah, I totally agree with Adeline. Like, please do not suka go and appoint executors and don't tell them about it, okay? Because you are giving your executors so much saikang. Sorry, you're giving them so much saikang. The least you can do is to inform them out front that they have this saikang to do, right? And I think usually what you could do is, practically speaking, once you make these documents, you could always get the practitioner, hopefully it's a lawyer, right, to be able to send an email with some basic instructions as to, to the people that you want to be notified that you have made an estate plan. And nowadays people are technical, quite technology savvy, right? You can log on to Gmail. Maybe 10 years later, the person passed away. You run a search. Oh, lawyer estate plan. Then the appropriate email will come out, and then all the documents will be there. All the information of who to contact. I mean, that's one suggestion, but it's up to you to practice good information hygiene. To organize the documents properly. To let the professionals know who you want to be notified that you have made all these instruments, and obviously where you plan to store them as well. And we have many important documents in our life, right? Marriage cert, insurance policies. It can't be that you have one person to store each document, right? So put all these documents together. I think it's a good practice.
Okay, interesting.
Sounds very naggy.
No, I think it's quite pertinent because sometimes in the course of life, people think I've done the document already, but they forget about the most basic thing, which is communicating it. Or maybe they just lost touch with someone, or they moved it one day. Yeah, okay. One of the things people ask also is in terms of mental capacity. So how do you determine if the person has mental capacity to execute these documents?
Question. Maybe I'll take that question. Doctor. Okay. So actually we assume that everybody has mental capacity. If you do think that they are making a strange decision, they are allowed to make strange decisions. They still have mental capacity.
Mm.
And let's say it's a language barrier, or the person has a hearing problem, then you have to do your very best to ensure that they do understand what you're trying to tell them. So those are the three main things to ensure. The first step. Then, so the first part is making sure that your patient understands, or the person understands what you're trying to get the decision. So mental capacity is very specific one. So you can assess a person for mental capacity for, say, finances, or mental capacity for placement to a nursing home, for example. So first, they must understand the question. Okay. After they understand it, they have to remember all the options that you give them. And once they understand and remember, then they have to weigh the pros and cons. When they're able to do that, then they come out with a decision. They must be able to tell you what the decision is. And throughout this whole process, you have to help them as much as possible, either with a translator, with hearing aids, anything that you can do to optimize their understanding. Now, if you've done all that and you find, hey, they really cannot understand, and they cannot remember, or they are unable to weigh the pros and cons because it's just too complex a decision, then that's when you say, okay, maybe this person doesn't have mental capacity to decide for where they're going to live, or financial decisions. They are unable to make that decision.
I think
so that's mental capacity.
Okay. I think you first mentioned that in a lot of situations, you usually presume they have mental capacity.
Yes.
But do actually people need a doctor certification to prove they have mental capacity, or is it the other way around?
Actually, we don't question the mental capacity until there's somebody who says, hey, you're making a very bad decision or unusual decision, and someone starts to question it. And usually if you're not able to make a decision because of a thinking problem, a brain processing problem, or a mental health problem, then it becomes a question of mental capacity.
Okay. Interesting. Good to know. I think we have covered a few. I hope we've covered breadth in terms of the topics of questions. So unfortunately, we are out of time. I know we still have a few questions we haven't answered, but hope maybe we can approach some, social worker or medical professional or lawyer to help with some of these questions as well. So very quickly, I just would like to invite each of our panelists here to leave us with one key takeaway.
I think for me will be, for you, the listeners that are out there, plan early for one's end of life. In fact, you should start the conversation with your family as soon as possible, while one is still lucid and mentally capable before it's too late.
Okay, my message is, it's always too early until it's too late. So live today, but always plan for tomorrow. Go and get your LPA and HB done immediately.
Wow, power. I stress already. I guess for me, it's really that in life, regardless of how wealthy we are, we occupy two roles. We are either a caregiver or care recipient. Sometimes it might be a hybrid of both. So it's important to make sure that if you're a care recipient, that your caregivers have all the help and instruments they need to perform their role well.
Thank you for the one key takeaway from all of you. So we have to bring our webinar today to a close. So at the end of this webinar, a survey form will pop up on your screen for your completion. So we appreciate if you can leave your comments, as it will be used to improve all future webinars. So if you're facing any legal inquiries and you're keen to register for a legal clinic session, you can write to help@probono.sg and someone will respond to your questions there. So once again, we would like to express our gratitude to, Mr. Shen Kiat here, Dr. Adeline Lam, and Ms. Julia Lee for sharing all your knowledge and experiences with us. I think it's been quite interesting. All things, even amongst us, we, hear things that we've never thought as well, even though they have all been, experienced in their fields for many, many, many years. So with that, we'd like to thank all of you for joining us today and have a good week ahead. Thank you.
Thank you.
Thank you.